Hey, Jennifer, we left off on these warnings that we talked about, right?
Yes.
Okay. Just 10 days later, does Mr. Musico contact Mr. Fox again?
Yes, he does.
Why don't you take a look at Exhibit 195?
Over here.
What is it?
A Facebook voice message that was transmitted. It's the one where you're talking to the phone and then transmit it over direct messenger.
And does it make a reference to the idea of a shadow group?
Yes, it does.
Okay, I'm gonna move for its admission.
No objection.
Objection.
Objection, Your Honor.
Admitted.
You can play it, please.
Now in that picture, okay, so what my part in this movement is, everybody thinks that, you know, what I do is crazy and stuff like that, and it's gonna get me killed and stuff. So in that picture, brother, you know, there's 5 different groups in that picture, and some people from out of town. Okay, so I've built bridges with different groups, okay, and built different groups into one group, okay? So we're the media group, we're the front line, trying to do different things, trying to get the positive publicity out there, trying to do everything in our power. We have radio stations, TV stations, and everything. We pass out flyers and everything. We're the face, okay? You guys are the shadows. You guys are the ones that are gonna come when they come for us. When they come for us, you guys are our backup and our defensive. You guys are the ones that are going to reset the system. If we are still around, we are going to assist 100%. If we are not, then, you know, then you need to step up and avenge us.
You go to Exhibit number 8, please. You can for page 8. Agent Dimple, in that last clip, what's this reference to the face, being the face?
So that's what Pete Musico brought up after April 30th, the protest while the House was in session. That's number 5. That became something that he kept bringing up repeatedly, is that he'll be the face of the movement and then the operators will be the shadow group.
If you go to page 8 for me, thank you. Is that the voice clip that we just saw on the left?
Yes.
And can you zoom in the right? It's not on trial. This is between Mr. Musico and Mr. Fox, right?
Yes.
Tell us about this.
These are direct messages on Facebook from August 26, 2020. Adam Fox stated, "Need to take a step back, brother. Go into the shadows with the rest of us." Adam Fox stated, "Our time is near." Adam Fox stated, "You got a sec for a call?" Pete Musico stated, "If I do, we are all going to. I'm a nobody. There are a lot of bigger than me, but I am." Pete Musico stated, "We are nobodies." Adam Fox stated, "Copy that. Let's stay that way." And then,
Indicates a video chat.
yes.
Okay, next page, please. Bottom section. Your musical says what?
This is August 27th, 2020. Pete Musico stated, "And they have to understand, we have to have something in place and ready when we take down what's there. We built this in 9 months, or I'm sorry, we built this one in 9 months." Adam Fox stated later in the same conversation, "Yeah, Barry hooked us up, bro." Pete Musico replied, "Barry is awesome." Adam Fox replied, "Yeah, he is."
Page 10, please. On the left side.
On August 30th, 2020, Pete Musico sent another voice clip through Facebook Messenger.
This is on the 30th, right?
Yes.
One second. Exhibit 195, please. Look at that.
Yes.
Tell me what it is.
This is the one. Okay, yes, this is another voice clip from Adam, Pete Musico to Adam Fox from August 30th.
And it's that one, correct?
Yes.
Okay, move for its admission.
No objection.
No objection.
No objection. Admitted.
Go ahead and play it.
195 is the one we just put.
Yeah,
One just
It's the
played.
same one that we just played.
Oh, I see. Okay, thank you very much. All right. And then take a look at one and finish this for me here. After that voice clip is played, what's the exchange?
Adam Fox said, copy that. Pete Musico replied, love ya, bro. Adam Fox said, love ya too, bro. Pete Musico replied, y'all do understand our parts and we all play one.
On the right,
So on September 3rd at 2020, Adam Fox sent a message to Pete Musico and said, it's here. Then later, Adam Fox stated, almost commie killing time.
why don't you take a look at exhibits number 196 to 202.
All right, I have them here.
What are those?
These are excerpts from a phone call between CHS Dan and Pete Musico from September 2nd, 2020, with the exception of, I don't have a 202 in my binder here.
Okay,
Just ends at 201.
okay. Are these phone calls, give me the dates again, and give me who they're between.
Sure. The first 196 is a phone call from September 2nd between Pete Musico and CHS Dan. Next, clip 197 is from September 2nd, same phone call, CHS Dan and Pete Musico. Clip 198 is a phone call from September 2nd, 2020 between Pete Musico and CHS Dan. 199, September 2nd, same phone call between Musico and Dan.
Then from 200 to 202, is that like 3 days later, another phone call between Musico and Dan?
No, 200 and 201 here are labeled as clips from September 2nd.
Oh, okay, more of the same.
Or
phone
the
call.
same, from the
Okay.
same phone call. And then I don't have a 202.
Okay, got it, thank you. I'll move right now, Judge, for 196 to 201, play those.
No objection.
My client was not a part of the conversation. No objection.
No objection, Your Honor. No objection. 196, 201 was it? Yeah, 201 admitted.
And what is the general nature of this phone call that Pete Musico makes with Dan?
Pete basically defines the shadow group and what his role is now moving forward in the Boogaloo, as well as he talks about how the group was started.
Okay, I'm gonna play, I'm sorry, Judge, did you admit them?
Yes.
Thank you. 196, please.
We are so on multiple different levels in our organization and our group. Do you know how many different things we have going on right now? And how many different, you guys are the shadow group. So what you guys did and everything was completely do exactly what we wanted. You guys did exactly what was needed and done. So the shadow group is working right now. Okay?
Right.
Man, the shadow group, you guys, do you think that you guys are gonna sit back and let something happen to 2 dozen people that are your boys?
No.
You guys are not. You guys got our fucking back regardless. You guys see 2 dozen boys at the ground or 100 guys at the ground being messed with. Dude, what's that gonna do? That's gonna make the shadow group stand the fuck up and be like, clack, clack, fuck you.
Right.
Because we're all boys. We all got each other's back.
Okay. On this one, what you guys did and everything is completely do exactly what we wanted. That's what Mr. Musico says, right?
Correct.
By September 2nd, at this phone call, was there already a reconnaissance of the governor's house up north?
Yes,
Okay, and who was a part of that?
Adam Fox
And,
and CHS Dan,
and,
Eric Molitor.
okay. And then what does click, clack, clack, fuck you mean?
That's racking the gun.
The next one, 197.
When I set forth this group, all right, because this Wolverine Watchman was my fucking idea. It wasn't Joe's. It wasn't anybody else's. Wolverine Watchman was my idea that I planted the seed in Joe's head. And when Joe started saying, talking to younger guys, I said, it's all you, buddy. Because at your generation, not mine.
Right.
70% of what Wolverine Watchmen went through and agreed upon, 60 to 70% of those ideas that were brought to the table, I had a hand in.
Right. No, good, more than that, I'd say.
I'm just saying.
Right.
So,
you know, from
and my whole intention on that group was to build a group, have it your area, somebody else's area, somebody else's area. You got fucking 30 guys, that guy's got 40 guys, that guy's got 50 guys. Dude, I used to run with gangbangers. That's how they were successful. Period.
Right.
That dude had 20 guys with him. That dude had 20 guys with him. That dude had 20 guys with him. Everybody had their own little sets, their own little crews, but when I called for a meeting, everybody showed up.
Right.
And that's the way I wanted to set this up. And that's the way this whole movement has gone.
Right.
98, please.
We're building bridges. We're joining different groups together. You know, that picture in front of the wood chipper. Can you hear me?
Yep.
Okay, that picture in front of the wood chipper,
Right.
that was 5 groups that we brought together. 5 different groups that were brought together for one common goal.
Man. You been
So
did they just meet up there collectively or what?
we all organized and freaking met up there.
Right.
One guy was from Indiana.
Oh no shit.
He had 4 guys from Indiana out there, man. That's how organized I'm making this movement.
Right.
That's how this movement is becoming. And I'm a big part of it, buddy. And I'm in the face. I'm in the line where listen.
Okay.
That's the only way we're going to be able to do what we do is to have the support and the backing of the people. So when everything, all the chips are on the table, they're like, fuck the militias. These boys mean fucking business. And we're going to set the tone for it. They set it for Virginia, and we're going to set it here for Michigan. They said it ain't going to be the militias, it's going to be the fucking straight Hawaiian shirt boys.
Right.
Period. It's all it's going to be.
100, please.
You know, like I said, you know, everybody was like, oh, you're a dumbass for being in the fucking spotlight like that. They're trying to turn us into the terrorists. Well, we have to have the fucking support of the people in our country to pull this shit off.
Right.
We are terrorists. Period. If we have the support of a percentage of the people in our country, then we are revolutionists. If we don't, then we are terrorists. Period. That's just the way it is. And I'd rather be a revolutionist, not a terrorist. You know, and we have to have, like you said, like last said, you know, we've got multiple different levels in this.
What's the reference here to last?
That's Last Croft, so that's the alias of Barry Croft.
201, please.
We're freaking, everything's moving like it's supposed to. So, you know, there's, like I said, you guys are the fucking, guys are the shadows, period. And I know that you guys are not gonna let the face get tarnished.
Right.
You know, and that's the whole thing is that we're, you know, hey, that's exactly it. We're working in waves. We're hitting hearts and minds right this moment. And then freaking hearts and minds, once hearts and minds are changed and the face and the media has changed their perspective, then we do what we do.
Right.
And that's when you guys step up and say, let's go.
Surprise.
Surprise! This is wave 3 and 4 and 5. Oh yeah, 7 and 8 is fucking. Hey dude, check it out. We need politicians.
Right.
Who wants to run for political office? And remember, if you're a tyrant, you're gonna die just like the rest of them.
But do you have a 201 in your, 202 in your exhibit book? I'm sorry, for some reason this.
I don't. It goes from 201 to 203.
Okay, it's fine. Agent Impala. I don't have any questions on this one. You can take it down. Thank you. Okay, is Mr. Morrison talking to Barry Croft at about the same time?
Yes,
Okay, I'd like you to put up exhibit 5 if you would. Page 7, please. Page 7. Thank you. Could you do the left side? Around that same time, Mr. Morrison is talking to Mr. Croft directly, correct?
correct.
Go ahead.
So September 2nd, 2020, Joe Morrison asks, how are you, my brother? And then says, Ben. Barry Croft replies, always the same for me, bro. Every day is a good day to die. Smiley face. Joe Morrison stated, "'Tis true, sleeping is hard, LOL." Barry Croft replied, "Indeed." Joe Morrison replied, "Glad you're still kicking and screaming." Barry Croft replied, "That probably won't stop until I'm dead, LOL." Joe Morrison replied, "You're gonna go out the same way you came in, kicking and screaming, covered in someone else's blood." Barry Croft replied, "I'm praying for it."
The other half?
Council, before you go, which number is this one?
This one, Judge, is exhibit 5, page 7.
Okay, thank you.
So this is later in September 19th, 2020. Joe Morrison stated, "It's long, brother, but everything will make sense after." Barry Croft replied, "Good copy." Joe Morrison replied, "We don't have much more time before we go home." Barry Croft replied, "Good, I despise this place." Joe Morrison replied, "I can't wait to see my Lord's face, glory." Barry Croft replied, "Yes, sir, none of this would exist if it wasn't for the fallen."
You can take that down, thank you. Does Mr. Morrison, right after he has that conversation with Barry Croft, the one that we just saw about kicking and screaming and dying covered in someone else's blood. Does he talk to the group on Wire about the dance?
Yes, he does.
Can you take a look at exhibit 203?
I have it here.
What day is that?
That's the next day, September 3rd, 2020.
Okay, and what is that you're looking at?
It's a wire chat log from the Wolverine Watchman main chat.
Okay, move for submission, Rich.
Any objection?
My client's not involved, no objection.
No objection, Your Honor. No objection. 203 is admitted.
Thank you for just put it up. Can you tell us about this?
Sure. This is the Wolverine Watchman main chat and wire. It's a chat log from September 3rd, 2020. Joe Morrison stated, "Boys, I want to do a rehearsal soon. The dance is near."
Okay, and what is that a reference to? A rehearsal soon and the dance being near?
Rehearsal is a reference to having training for the Boogaloo. The Boogaloo is the dance.
Why is the Boogaloo the dance again?
From the origin of the word, from the electric Boogaloo in the 60s or 70s. That's how the whole Boogaloo concept went viral as this started out.
Okay, keep going.
User Schleem stated, "I'll bring a skateboard for realism," with a wink emoji. User Fedboy said yes. User Choose to Shrug, that's Curtis King, stated, "I'm game when." Joe Morrison stated, "I figured another Sunday here soon, but not during the FTX weekend." At Eat a Dick.
What is that a reference to?
That's a reference to training again with the Wolverine Watchman leading up to the Boogaloo.
Okay, keep going.
Bad Boy stated next weekend. Boogaloo. Joe Morrison stated that's FTX. Fed Boy stated Fed Boy's Trent Newcomb. What's that? Joe Morrison stated training at Gunny's.
What does that mean, training at guns?
That's the FTX in Luther, Michigan, which is Ty Garbin's hunting property, which occurred during the weekend of September 11th, 12th, and 13th. That's when Adam Fox came and they did a night recon of the governor's.
I would like clarification of they, Your Honor. I guess I object, they, but who's they?
Sure. So none of these defendants were present, and there was 3 vehicles, which included Ty Garbin, Caleb Franks, CHS Dan were the members of the Watchmen who went forward on the night recon and did the Luther training.
Thank you.
And Adam Fox, Barry Croft were also there, correct?
Yes, yes,
Engaged in this nighttime surveillance of the governor's house, correct?
correct.
Okay, keep going down.
Steve Schleen said at Boog Daddy Bunyan, "You're still going to do that?" Or excuse me, you still going to that? Joe Morrison replied, "I might go the last day. Please don't think of the guys who left. No, still our brothers. They're more of a shadows group."
Okay, so Mr. Musico is talking about the Shadows group and shadows, and then the next day, Mr. Morrison is talking about the shadow group. Is that right?
That's correct.
Okay, keep going down all the way, I think. To the bottom. And 2 days later, on the 5th, what does Mr. Morrison say?
He said, "We're getting closer."
Okay, thank you. A few days later, is there another call with Dan between Pete Musico, Joe Morrison, and Dan?
Yes,
Okay, and when you look at exhibits 204 to 206,
yes, I have him here.
is there more reference to the shadow group?
Yes,
Okay, I'm gonna move for submission.
Any objection?
My client's not a part of the conversation, no objection.
204 to 206 are admitted.
Thank you. 204, please.
So organization getting a lot better. Getting a lot better. People are wanting to be out in fun. There's a whole group that wants to be out fun.
Right.
Because we all have the same idea. If we do this without the support of the people behind us, okay, we all agree, we're fucking terrorists.
Right.
But if we the support of the populace, then we are revolutionists. Right or wrong?
Right.
Okay. So what you guys are doing is great, fine and dandy. But you can't do what you do without us doing what we gotta do. Because you can do what you're doing all day long. And man, I'm there to fucking back up brother up. But I mean, we're painted in a real bad light, period. And everybody's back off and started fucking hard. They're gonna be painted in a bad light. Guess what? In a bad light anyways. The only way to confront that is to fucking yes. That people feel that we are not what it says we are.
Right.
The phone started cutting out a little at the end there, is that right?
Yes, ma'am.
Okay, 205, please.
Put my fucking face out there.
Right.
I'm not afraid at all. I got God on my side. Them on my side, I ain't worried about shit. Because what's the worst that's gonna happen? They gonna send me to paradise?
Right.
You know, that's all I gotta say. You know, that's the way I feel about it.
Right.
Some people say it sounds like a religious extremist, you know? I mean, you know, I'm dying in the name of Jesus Christ, so, you know, all I'm doing is defending myself. And you're gonna shoot and kill me, then yeah, I'm gonna fucking go to paradise.
Right. No, I got you, man. Dig in, you know?
Oh yeah, I'm dug in. I'm fucking bed. My face is all the fuck out there.
Right.
This part where he called himself a religious extremist, is that right?
Yes,
There's a mention about paradise, is that right?
that's correct.
And here he says, all I'm doing is defending myself, correct?
Correct.
Is this another instance of someone in the group talking about their actions?
Objection, speculation, lack of foundation. I could go on for days.
Yeah,
Judge,
why don't you go ahead, rephrase.
sure, Judge. He's saying, all I'm doing is defending myself, correct?
Correct.
You were asked questions before about, other chats and other times that people talked about their actions being defensive in nature, correct?
Correct.
Is this another time where someone's talking about their actions being defensive?
Again, objections.
This is directly what he brought up before about, can you give me dates and times and other chats talking about defensive things? This is one. I don't know why he's objecting right now.
Because it's completely out of context, Your Honor. We're talking about defending on July 7th when my client has a meeting at his house and he says we're not blackbagging politicians. We're strictly defending ourselves and someone else. Now we have this worried about, is my day coming, my day in paradise? I'm just defending myself. They're two totally different conversations. It's spear speculation and it's completely taken out of context. How this gets equated to my client who's been gone for over a month now at this
I'm
point.
not equating it to his client. No one said I was equating it to his
That's exactly
client.
what she's doing.
Yeah, because one, I mean, she's asking the witness to interpret this statement. Now, reading this statement and listening to these phone calls, how could you possibly interpret this to anything? If they want to make that argument to the jury, fine. But asking this witness to interpret what he means, and I'm sorry, I gotta fit this screen again. What he means when he says defending himself in this rant, it can only be speculation.
And on behalf of Mr. Morrison, we would join this same objection, Your Honor. This is what he's saying here does not attribute to anything other than what is in his head, being Mr. Musico's, and nobody can testify to what that is other than Mr. Musico as to what he's talking about in this, or what his emotion or his mindset is regarding this. The agent can testify, this is what was said, but to go any farther is absolute speculation.
Response.
The question before the agent, as I recall it, Judge, is, did the group talk about these things? And his answer was yes. And then Mr. Kirkpatrick stood up and said, well, we need more context, that we need specific dates and times and all of this. And I said, okay, I'll go back and I'll look up some. This one is just actually in the lineup already. I didn't add any more to that, Judge. But here, he specifically talked about defending. It's the same word. Defensive and defending are the same word. So I'm just not sure what
not when
this
you're-
objection is about.
Not when you're combining it with Jesus Christ and the religious zealotry or extremist, that's totally different, right? Now we're bringing in, excuse me if I can finish. Now we're bringing in something totally different to try and connect all this together.
You mean the religious extremism that's being espoused?
I beg your pardon, Your Honor?
Do you mean him referencing religious extremism?
Yes.
And also, Your Honor, just like the hearing we had on Friday regarding the comment about the governor, how they were talking about the governor. I asked him, is this what you mean when you say the taking of the governor? Well, I can't say what was in his mind. I can only read the words that were said. That's what he said on Friday. And now he's going to speculate and give his opinion on what this means.
What was the date on this one approximately?
9/5/20, Judge.
Month and a week and a half.
And when did they first think they had an informant?
The previous exhibits where they considered Dan to be potentially a mole, that was 8/20 or 8. Yeah, I believe that was 8/20, Judge.
No, well, wait, yeah.
Right in there. I just. Okay. I'm going to sustain the objections for right now. If you give me something more, I'll definitely consider it.
Thank you, Judge. Moving on to 206, please.
You guys didn't actually exercise our backup, and you guys were all plugged in as the same exact same people.
Right.
Every single one of us are all plugged in together, which is funny.
Right.
I really find that hilarious as fuck.
Yeah, that's pretty crazy.
I mean, we're all the same fucking group. You know what I mean? We're all still the same fucking. We're all still the same. Doesn't matter. We're all to the same fucking cause except for minds. Hearts, I see it. Minds changing hearts and minds, face-to-face communications, networking with fucking people, like I said, man, this has to be ordained by God.
If you can take that down. Can you put up exhibit 10, please? You told us, Agent, the date of the, did you tell us the date of the first reconnaissance or the first surveillance at the governor's house? What was the date of that?
That was August 29th, 2020.
Okay. And then the second surveillance at the governor's house is what date?
That was September 12th, 2020.
Okay. And so in August, late August and September, Mr. Musico communicating with Mr. Fox.
Yes.
Okay, next page, please. Mr. Morrison communicating with Mr. Fox. August and September.
Oh, yes.
Okay, next page. Is Mr. Morrison communicating with Mr. Croft in that time range?
Yes.
And the next page, Mr. Morrison, or sorry, is Mr. Musico communicating with Mr. Croft?
Yes.
Okay, thank you. You can take that down. Mr. Morrison and Mr. Musico do not attend that FTX in September, that weekend of September 12th, correct?
Correct.
And you already talked to us about what happened at that. And you already told us about who was involved in that. How many of the people involved in that nighttime reconnaissance of the house, how many of people were Wolverine Watchman members?
3 members.
Originally.
There was 3 original members of the Wolverine Watchmen that went on to be operators and did the nighttime recon.
And who were those people?
Ty Garbin, Caleb Franks, and CHS Dan.
Thank you. Did anyone in that September, attendees of the September FTX, which not include these 3 individuals, did they ever talk about explosives?
Yes.
Okay, and was there a bridge discussed specifically?
Yes.
Tell me about that a little bit.
During the nighttime recon, Adam Fox and Barry Croft identified a bridge leading up to Elk Rapids, and they decided that they should blow out the bridge so that first responding police officers from the township of Elk Rapids couldn't respond to help fight the kidnapping of the governor.
Okay, exhibits 247 to 248, please. What are those?
These are photographs of the bridge during the nighttime recon.
Okay. Those?
248 was taken by Adam Fox as he was under the bridge, and 247 was taken by an FBI undercover agent who was with him, and it's a photograph of Adam Fox taking a photo under the bridge.
Okay, I'm gonna move for their admission, Judge.
Doesn't pertain to my client, no objection.
Same.
Any objection?
247 and 248 are admitted.
Thank you. If you could put up 247. Tell us what's in here.
That's Adam Fox on the left, and this is under the bridge in Elk Rapids. It's the main highway going north from the town of Elk Rapids up towards Birch Lake.
248, please.
This is a photograph that Adam Fox took of the underside of the bridge when he was up there on the bridge abutment.
Thank you. You can take that down. Arrests in this case were effectuated, you told us before, October 7th, 2020. Is that right?
Correct.
Okay. And was Mr. Musico and Morrison's property searched by the police?
Yes, it was.
And how do you know that?
I was involved in helping write search warrants for the property, and then I was in the command post when we received updates and results from the property, and I've had a chance to look at the search warrant tab that you provide to a judge after the property is searched.
So you know what was seized and what was not, is that right?
That's correct.
Okay, thank you. And can you tell us about some of the things that were recovered that were relevant to this investigation?
Sure. So for Joe Morrison and Pete Musico, their uniform, so to speak, was recovered. So their kit and then their long gun and sidearm was recovered.
Okay. What about body armor?
Yeah, so the kit is the body armor.
Thank you.
Basically, it's you got your duty belt and your body armor, your ballistic vest with the armor.
Are you familiar with the pictures from the search warrant that was executed at the home 8008 Dunn Road?
Yes.
Okay. And are you also familiar with exhibits 2? Okay, so let me go back. 208 to 219, please take a look. And Judge, I've discussed this with the attorneys, and I don't believe that there's an objection to Agent Impla testifying to this.
Is that correct?
That's correct, Your Honor. Just save a lot of time and.
Not my client's house, Your Honor. I have
That
no
is correct.
objection to any of this.
208 to 219.
Yes, I have them there.
Are they pictures from the search warrant?
Yes, they are.
Okay, what about 224?
Yes, that's picture from the search warrant.
Exhibits 250 to 259?
So 250 to 259 is photographs that I took after going and viewing the evidence in Michigan State Police evidence lockup.
So all these are things you have in evidence physically, but they just are not in the courtroom today. Is that right?
That's correct,
And these are pictures from that.
correct.
Okay, thank you. I'm gonna move for other admission, Judge. So it's 208 to 219,
224 and
250 to 259. Yep.
any objections?
Not my client's home, no objection.
No objection, Your Honor.
No objection, Your Honor.
Okay, 208 to 219 are admitted, 224 is admitted, and 250 to 259 are admitted.
Thank you, Judge. Is one of those a sketch that you prepared? You tell me which
220.
number?
220 is the sketch that I prepared.
Okay, can you put that up? Would you put it up on one side of the screen? We're just gonna roll through these. We're looking at a sketch here on the right side of the screen, is that right?
Correct.
Do you zoom in to the main house here? Adam, I'm looking for this area, just right. Is it possible to put up the pictures on the left side of the screen? Double pane it, not while Zoom. We have Mr. Musico's bedroom up here, correct?
Correct,
All right, bathroom next to it,
correct,
table in a sort of living area here,
correct,
Mr. Morrison's bedroom here,
correct,
okay, and the kids' room here, correct?
correct.
Front door,
Yes,
what's this area over here?
that's a trailer that other family members were staying in. I believe Mr. Musico's daughter and her husband.
Okay, thank you. I'm gonna have you not zoom and then put it back. Then bring up pictures on the left side if you would. Thank you. Okay, so what can you tell me about this picture? This is, I'm sorry, identifying exhibit number 208 for the record. What is this?
Photograph of a handgun in a dresser drawer in Joe Morrison's bedroom.
Okay, that's 208, 209, please.
Rotating the sketch.
You know what, let's kick the sketch and we'll just use one pane for the pictures. What is this?
That's a photograph of a plate carrier and a radio in Pete Musico's room.
That's 209, right?
Correct.
210? What's this?
It's a photograph of an ammo can with rifle magazines, and I believe this is from Joe Morrison's room.
Okay, 212,
211.
211, thank you. What's this?
This is a photograph of the notebook. We had the excerpt earlier as an exhibit, and this is from Joe Morrison's room.
On the right side, you know what, 212, please. That's the left side of the book.
That's correct.
That's the ranking structure we looked at before.
Correct.
Okay, 213. Right side of the book.
That's practicing signatures.
Okay. 214.
Just the photograph of the book in place when it was found.
Okay, 215. This.
This is a photograph of Joe Morrison's kit and go bag on his bedroom. I guess.
And is it your understanding that these pictures were taken while the evidence was in place, meaning house wasn't tossed and then these pictures were taken, correct?
That's my understanding, but I wasn't on scene,
Okay,
just talking to officers.
so that's 215, correct? 215, thank
Yes.
you. 216, please. What's this?
This is a photograph of Pete Musico's plate carrier with ammo in the truck.
217. This,
This is a close up of the same kit in the truck.
okay, see patches there. What are those patches?
Mujahideen, and then there's a Christian Crusader cross, Forgotten Country, and then Infidel.
Okay, that's a Crusaders cross.
That's a cross.
Okay, thank you. 218. What are we looking at here?
This is Pete Musco's bedroom with a bag and a rifle.
Okay. 219. What are we looking at here?
Joe Morrison's bedroom with his rifle kind of near the nightstand.
Left side of the nightstand,
That's correct.
putting up.
Yes.
224, please.
This is Joe Morrison's bedroom, the floor, and then some targets.
250, please.
These are the photographs that I took in the evidence room here in Jackson. This is Joe Morrison's plate carrier and kit.
251.
This is Pete Musico's kit.
252. What's this?
This is the Anarchist Cookbook, which was found in Pete Musico's bedroom. It's a black binder, so then I opened it up and took some pictures of pertinent pages.
What is the Anarchist Cookbook again?
So it's a instruction manual on guerrilla warfare and fighting insurgency.
252, please.
That was 252.
Thank you. 253. Could you zoom on the right side? I don't want to go through every single bit of this, but could you tell me what sort of chapters are, what the chapter titles are?
Yeah, so chapter 4 is explosives and booby traps. Chapter 2 is electronic sabotage and surveillance. Chapter 3 is natural, non-lethal, and lethal weapons.
Okay.
Chapter 1 is drugs.
254.
This is chapter 4.
255.
This
Can you
is
zoom in on the left side? This.
This is the household substitutes list that Mr. Musico had sent out that I saw on Dan's phone on wire the first time I met him. So these are the household substitutes you can use to make explosives.
Thank you. 257. What's this?
That's schematic and instructions on how to build a grenade.
Why was this important or relevant to your investigation?
Because Mr. Musico had talked about obtaining a handful of grenade bodies. He had timing fuse in his house, and he had described throughout the course of the investigation how he knew how to pack the grenade with black powder and silicone and how he could make it go live.
258. What's this?
This is Mr. Musico's uniform, so his kit with his sidearm and his long gun.
259.
This is Mr. Morrison's uniform, so the kit with the sidearm and the long gun.
Take that. Tell me about what was not found on the property during the search.
We didn't find any C4. We didn't find any tannerite or explosives. We didn't find any of the hidden weapons caches that he described previously.
Where was Mr. Bella arrested?
In South Carolina.
After Mr. Morrison was arrested, did you have a chance to have your attention called? Well, tell me what jail calls are.
The jail calls, when you're arrested and you go into whatever lockup you're at, all your calls are monitored. And one of my common investigative techniques would be to listen to the jail calls of defendants right after they're picked up.
And do they tell you when you're using the phone in a jail that you're being recorded?
Yes, it's on the recording in the jail that, all calls are recorded. You have to set up and go through a system in order to make a call out.
Put money in an account, right?
Correct.
Okay. Put a PIN number in, right?
Correct.
And have you reviewed a call that's in exhibit number 221?
Yes.
Okay. Can you tell me what that is?
So this is a jail call that Joe Morrison participated in with Jada Morrison.
His wife?
Correct.
Okay, thank you. And a mover submission, Judge?
As pertaining to my client, no objection.
No objection.
I would object to this being into speak musical. This is now a statement after arrest. Surely court cannot, no, I'm sorry, cannot stand, cannot find this to be a co-conspirator statement. He is now been arrested.
Offering it as a co-conspirator under 801D2 as an admission.
Admitted.
Thank you. You could play exhibit 221.
Well, Your Honor, if she's offering now as a hearsay admission, I now have a Crawford objection.
Objection?
Can't cross-examine.
Go ahead.
I can't cross-examine the declarant.
Just the declarant is his client.
Client.
No, the declarant is my client.
Exactly.
Oh, Morrison, yeah.
I'm sorry, I don't. The declarant is,
The declarant, he said, was Joe Morrison. Joe Morrison is my client,
right?
Right.
not Mr. Johnson's client. Therefore, Mr. Johnson has no opportunity to cross-examine Joe Morrison unless my client chooses to take the stand.
Second, let me read it.
Judge, it can apply if it's an admission to him, and so you can give a limiting instruction that this applies to Mr. Morrison. I'm not following the Crawford objection thing, Judge, but you can give a limiting instruction that this is Mr. Morrison, and a phone call with his wife, and it applies to Mr. Morrison.
Okay. Ladies and gentlemen, as far as I'm going to allow you to hear what was said, but this applies only to Mr. Morrison. Any use you've got for this applies only to Mr. Morrison, not the other detective.
Can you give me the date of this?
May 11th, 2021.
Thank you. Go ahead and play. It is admitted, Judge?
Yes.
Thank you.
So I talked to your attorney. I have a question for you. No, he's not straight on his freaking. Yeah, he's not funny, so he told me to ask you.
Your Honor, I'm going to object to this right here. This is going into attorney conversation. If the previous attorney was utilizing
Hold on.
this
Let's just let him pause
information,
it. Let him pause it.
if previous counsel was utilizing information and utilizing his wife to, as a go-between,
Doesn't fall on attorney-client. If he wanted attorney-client, he can go into the jail and he can have a meeting. Anything said between the attorney and the client is privileged. He starts involving third parties who's not employed or an investigator for it. There's no attorney-client privilege. Go ahead.
Thank you. Good start the meeting.
So I talked to your attorney. I have a question for you. No, he's not straight on his freaking. Yeah, he's not funny, so he told me to ask you. Who invited you out to the June 6, 2020 meeting in Ohio and filed Facebook text schedule?
He wants that answer over recorded line.
Yeah, he said, can you ask him?
It was over a phone call. DC is all I'll say. Dad should know who that is.
DC?
B.
DC?
Yeah.
Let's see. Okay, facing side charges?
What?
Facing side charges?
Who is?
I'm asking, is that who, is he?
Yes.
Okay, I'm just making sure, I was making sure we had the same dude, I know who you're talking about.
Yeah.
Well, I'm sorry, your attorney wanted to know.
I get that. I don't know why you didn't just zoom up here.
Huh?
I don't know why you didn't have a Zoom meeting.
Because that's just plain as day, he just needed to hear it. I'm guessing, I don't know, there's a reason why he had me ask you.
I get that. I'm just,
I got what you're saying, honey.
Judge, that's all the questions I have at this time. Thank you.
Okay.
May we approach, Your Honor?
Run up. So I'm gonna dismiss you for a little bit and we'll take care of those and then move forward after that. Take them out when you get, after you get us off of the streaming.
my client training terrorists. We have Dan Harris, AKA Beaker. We've got Exhibit, beyond Exhibit. He likes explosives. He does this. He's at my client's residence on July 7th on the supposed ghost group, which I'm going to deal with in cross. But Dan Harris is at that meeting with this supposed ghost group that goes on with the informant to kidnap the governor.
To what?
Concerta to kidnap the governor. The plot, which my client's long gone. Concerta, Your Honor, I didn't make an argument about Brandon Concerta at the hearing that we had before trial. I think the court recalls that because at that time, Ty Garbin wasn't, it was an issue of whether Ty Garbin was going to testify or not. Concerta, I can't count on my hands and toes how many times they've mentioned Brandon Concerta. Tax. Wayward and tax. I can't count how many times the prosecuting attorney also put up Brandon Concerta. In fact, they showed a video of my client training with Brandon Concerta. That's the PT Cruiser, Your Honor.
Yeah, I know.
That's the PT Cruiser where they're claiming that was offensive. And so this jury is looking at this case, and supposedly my client is training all these individuals for materially supporting for a terrorist act, when in fact those two were found not guilty by the very terrorist act that they're being charged with materially supporting.
How do you get around the difference in the charges?
Here's how. They're charged with materially supporting a terrorist act, as the court is aware.
Right.
What the prosecution must prove is that my client knowingly materially supported a terrorist act by training this, that, and the other thing. And the court's well aware of the statute. The very and only terrorist act in this case is the alleged plot to kidnap Governor Whitmer. That is the terrorist act in this case. We can sit and look back at the 3 days of evidence we've done, none of which they were charged with. They're not charged with making a terrorist threat. They're charged with materially supporting a terrorist act. There's no facts and evidence that they fired upon any police officers, tried to kill any police officers. They're not charged with any type of threat or any statements they made. They're charged with materially supporting that alleged plot to kidnap the governor through Adam Fox. That's how I get around that. Well, that's how I would ask the court to allow me to get around that, Your Honor, is that we're talking, it's not like they went to trial for making terrorist threats or for possession of explosives or possession of a firearm. And there was something in the trial where, well, you know what, it has nothing to do with my client because possession of a firearm has nothing to do with this, or explosives has nothing to do with this. They went to trial for conspiracy to kidnap the governor and they were found not guilty. And it wasn't me that opened that door, Your Honor. It was the prosecuting attorney that opened that door. The minute they said in their opening, there's Paul training a terrorist. They're training Adam Fox. They're materially supporting for this terrorist act to kidnap the governor of this state. They opened the door. I think it's relevant. I think it's probative. It's more probative than prejudicial. As we stated in our argument that we had a couple weeks ago, Your Honor, when you actually ruled in my favor to allow the acquittals to come in, a skilled prosecutor ought to be able to, well, you know, hey, they were this, they were that. But the fact that a jury hears that they were acquitted, it doesn't confuse the jury. It shouldn't prejudice the jury because they just spent 3 days hearing about what a bad person Mr. Beller is and how he's trained these terrorists. But yet, I think the jury has a right to know. I think fundamental fairness calls for the jury to know that all these videos you see with my client, with all these guns and these trainings, those guys are found not guilty of conspiring to kidnap the governor. So I'm asking the court to allow me to address that. It only take me a minute to do it with Mr. Impola, or I'm sorry, Agent Impola, I apologize. It only take me a minute to do it with Dan. It only take me a minute or two to do it in my closing.
And John, add on to that briefly. When the court does the balancing test in terms of relevancy, particularly determining whether or not the probative value is outweighed by the presidential effect. I'd ask the court to take into consideration why Ty Garber didn't hear testify and why these people aren't here testifying. Ty Garber was somebody who was taking an agreement that included cooperation. The people are not calling that witness. They took him off the witness list, I believe, the Thursday before this trial started. And I believe he's going to plead the fifth. Harris and Caserta have both indicated.
He's gonna plead the fifth because then if he gets in here and testifies, he could be facing other charges from the state level.
But here's the thing, y'all. They were mentioned in his cooperation agreement. Remember, I read the agreement. The agreement, paragraph 7, required him to cooperate with all federal and state prosecutions while he was on the witness list. Let me ask you something, Yana. And now Ty Garber's already testified, and we talked about.
If I was one of you, when I was representing him, before I'd let him testify, I'd want immunity from the state prosecution. Even though the federal agreement says it, he could always fall back on the fact that he wasn't granted immunity. So if he gets and testifies in the state level, that he could face potential new charges without the immunity granted if the Attorney General's office or the well, in this case, Attorney General's office would have to grant immunity.
They're mentioned in the immunity agreement that he must cooperate with any state or federal investigation, including testifying at any subsequent hearings. And I asked the court is practice. I mean, fortunately, we're not in front of a judge that never practiced.
I did a lot of criminal law for a lot of years.
You think if Ty Garber's suspected testimony was that this group was a terrorist group from day one, they wouldn't be calling? They're not calling because he said exculpatory things in his federal trial. That's why he's not here. I can't compel him to testify. So, and that's another issue in terms of availability. But that is why I agree with, Mr. Kirkpatrick in terms of the other two guys who I believe they have now made res gestae witnesses by mentioning them specifically in opening statement and admitting exhibits that depict them.
And simply, we would piggyback on that, Your Honor.
Response?
So I guess we're relitigating the motion we litigated a week and a half ago, where we're at. And we took Ty Garber off the witness list so that the issue wouldn't be, germane. Mr. Kirkpatrick has come up with a new Ty Garber. It's Dan Harris and Brandon Caserta. Okay, in terms of what was said during opening statement, I completely disagree with Mr. Kirkpatrick as to what he attributed to the opening statement. And it doesn't matter anyways. The court instructs the jury. Opening statements are not evidence. Okay, so as seems to be common, Kirkpatrick cites fundamental fairness as this basic rule of law as to why this should come in now. What I do know is, what I remember from the hearing is the court was clear that what's good for the goose is good for the gander. Now, everybody stood up in opening and admitted that Croft and Fox were terrorists. Thank you very much.
No, I did not.
So with that in mind, if they're going to come in with, if they want to come in with the acquittals of Mr. Harris and Mr. Caserta, then the convictions of Croft and Fox certainly come in too. Now, what I would ask the court to do is to think about a couple of things. We did cite, I believe, a Michigan Supreme Court case that made introducing the results of the federal trial dubious. Okay. John Palast argued that motion. I mean, his understanding of the law is much better than mine, but I know that the reasoning of the court in the appellate court was quite clear that it was questionable. We took Ty Garber off the list to remove that issue on appeal. Now, the court, I think, has locked on to the issue in this relitigation of this consideration, and that is, wait a minute, the charges here are different than the charges over in Grand Rapids. And when we talk about 403, I had a judge once tell me evidence is meant to be prejudicial. You know, admissible evidence is going to prejudice one party or the other. And that's not what 403 contemplates. 403 contemplates a confusion or misuse by the jury of evidence, okay? And this is, I would suggest to the court, a fairly fertile place for the jury to misuse this kind of evidence as to the acquittals. I mean, as to the Croft and Fox's convictions, I mean, it's already been, you know, told to the jury in opening statements by the defendants that they're terrorists. So I don't see how any harm could come of that. So what I'm asking the court to do is, because Ty Garbin isn't testifying, and Dan Harris and now they've glommed on to a new reason to bring in the acquittals. I mean, they want it in. I get it. It's not like it's not like I'm missing the point that they try to achieve, but it is not relevant as to any of the issues that are material to this jury, to these charges. So I guess three things. One, I'm asking the court to not let it in. Number two, if you do, then obviously the convictions would then be just as relevant. And number three, if that is the path we are going to go down, I very much beg the court to require all counsel for each defendant to agree this is part of their trial strategy to admit this evidence. And it's been considered, that's the way they wish to proceed.
Yana,
Go ahead.
I've just been notified that the Attorney General's met with Ty Garbin's lawyers for several hours. His attorney said that he was going to testify in the state case. So he was not going to come in here and plead the fifth, is the information that I have.
And Your Honor, I just need to briefly respond to whenever.
Yeah, and, I mean, Ty Garbin can't testify until we petition this court under the statute for immunity, okay? We have not done that, okay? So until that occurs, until he gets immunity through that process, his Fifth Amendment right is alive and well.
Your Honor, just briefly in response, I promise I'll be brief. Yeah, when I talked about the evidence, I wasn't talking that Mr. Goldstein put in. I wasn't talking about just what was said in his opening. The video that he talked about in his opening is facts and evidence. It's been admitted. I don't know the exhibit number, but it's an exhibit. It's been played. It's been admitted by the court. The PT Cruiser, both videos, both from inside and both behind it, have been admitted. The countless text messages, wire chats, communications, recordings of meetings that included Dan Harris, Brandon Concerta, AKA Tats, AKA Waybright. They've all been admitted into evidence. And a lot of those make significant comments and statements about explosives, about trainings, about this, that, and the other thing. And I agree with the prosecutor. Court allows us to talk about the acquittals of Dan Harris and Brandon Concerta. I'm perfectly fine with the jury knowing that Adam Fox and Barry Croft got convicted. Now, I don't know about brother counsel. I know that the prosecutor would like for all three defendants to be queried on that issue. But as far as my client is concerned, I do believe it's relevant. And it's more relevant for my client than it is anyone else. I think, I mean, it's still relevant to all three of them just because of all the messages that have come in over the last 3 days and all of the statements. And I mean, how many times did you hear the prosecutor reference Tats? Well, Tats is Brandon Concerta. So, and Brandon Concerta has been found not guilty of conspiring to kidnap the governor of Michigan. So I think, Your Honor, I think it is relevant. I don't think that it's going to confuse the jury. I don't think it's going to be a waste of time. I'm not going to go into detail, Your Honor. I'm not going to sit here and beat a dead horse. And I'll go one further, Your Honor. I'm not going to say in my closing, well, since they were found not guilty, he shouldn't be found not guilty. I'm not going to say that. I'll let the jury give this the weight that they deem appropriate. But I think it is necessary for the jury to hear this, Your Honor.
Anything else from anyone?
No, Your Honor.
I would simply just say, Your Honor, and I agree with Mr. Kirkpatrick. I've not spoken at length recently with Mr. Morrison in regards to this. If the court would want Mr. Morrison to affirm or deny after our conversation as to putting in the convictions of Croft and Fox, sorry. I'm happy to put that on. I'm happy to have a conversation with him, find out where he stands and put that on the record if the court would so desire, as was represented. But again, we've not spoken about this since the trial began.
Well,
But I will say on my behalf that I also agree, and I'm trying to re-stand up, but I do think it's relevant. I think both sides are relevant. I don't know that there's a downside that outweighs the upside of putting any of this information in, right? It's the truth and it's the whole truth. This is what has occurred, right? This group was convicted. This group was not. And they were all in this together. And if you're going to say that there was some aspect that these guys were not guilty, then that in and of itself is every bit as important and relevant to the truth and the whole truth as Croft and Fox are guilty.
Can see and do agree with defense counsel that there is relevancy here. See that. But when I'm balancing this, I've also got to look at the probative versus prejudicial. And the fact that we're dealing with different charges as attorneys, I think that's much easier to understand. But when it comes to a jury of 12 lay people to understand those differences, I'm concerned that it would be overly prejudicial to allow that to come in to the swaying the jury. Well, if they got off, why shouldn't these guys get off? When it was a completely different type of case. I mean, there was a lot of similarities, but the charges were significantly different. And more serious. I'm not going to change my opinion from earlier. I'm standing by it. They're not coming.
I'm sorry, Your Honor, you did rule that we could, but now your ruling is we can no longer talk about the acquittals, correct?
You don't want anybody to testify.
Well, I don't, here's the thing, Judge. I personally don't need Ty Garvin. I don't think I need Ty Garvin to testify. I'm going to stick with with what I have from the people, but you had originally ruled that I could talk about the acquittals, but then we agreed before trial that I would stay away from it because I wasn't, I didn't want to taint I didn't want to have a mistrial. I didn't want to taint the jury, and the people agreed. We had a discussion, but my problem is that when they did that, they opened the door.
We can do that without confusing them.
Well,
because now after hearing 8-9 days of testimony, they're present. How do we make sure they understand the difference between the charges?
We could do a instruction that says it was a different charge, but see, the thing that I'm having a hard time getting over, Your Honor, and I'm going to respect the court's ruling, whatever that may be.
I want to hear the argument so that.
The argument would be, we could do a limiting instruction. We could actually do an instruction that says you've heard testimony that there was an acquittals. Just because an individual was acquitted in federal court, I'm shooting from the hip right now, Judge, but just because an individual was acquitted in federal court for conspiring to kidnap the governor, doesn't necessarily mean that these defendants still didn't materially support a terrorist act. I'd have to sit down and map it out, Judge. But this is the crux I'm getting, and I respectfully disagree just a little bit with the court on one issue.
That's your job. Disagree all you want.
The whole crux of this case, the whole crux rises and falls on whether or not my client, through his training, materially supported a terrorist act.
Right.
That's it. If the people can't get there, they don't get gangs, because gang requires you to break the law. So if there's no conviction, there's no gang. If there's no gang, there's no felony firearm.
Right.
The whole issue here is that the people are alleging that my client materially supported these terrorists to go out and kidnap the governor. And when they play videos of him training, more importantly, Your Honor, they put information up there from individuals that are not even testifying. So Ty Garbin, he's not testifying, but he did testify, Judge. He testified because every time Agent Impala read a thread that he wrote or played an audio where Ty Garbin is speaking or Dan Harris is speaking or Brandon Concerta is speaking, they testified. Did they testify on the stand? No, but they testified. And the people were allowed to get all that information into the jury. And now the jury, in their mind, is thinking, wow, Mr. Beller trained these guys, Brandon Concerta and the PT Cruiser trained at the Wisconsin training. They're talking about bombs. They're talking about explosives. They're talking about this. They're talking about that. I think it's very relevant for the jury to hear that, oh, by the way, Dan Harris, AKA Beaker, and Brandon Concerta, AKA Waywright, were both found not guilty of conspiring to kidnap the governor, which is the charge that they are alleged to have materially supported, Your Honor. And I didn't open this door, Judge. I think they did when they put all of these messages in there and these audios in there.
Yeah, to answer the court's question, we can do a other acts instruction for this case. We do them all the time
Right.
for rape cases, child molestation, DV. And to answer the court's question, I didn't call Barry Croft or Adam Fox terrorists in my opening statement. And in terms of impeachment, I think once he read the statement, I think the rules allow me to impeach Agent Impala as if he is Ty Garbin. Once he reads that statement, you know. So I'm kind of fine there.
No idea.
Any response?
I mean, what are we gonna do? We're gonna read the jury instruction to the federal crime, to the jury and the elements, and then, you know, the elements to our crime and say, be aware, ladies and gentlemen. I mean, really, I'm the crafting of the limiting instruction that really achieves the end of the court's concern. I wonder if that's even possible. You know, that's the first question I have, is since we haven't, you know, gone to that yet. I mean, to try to actually draft something up. I mean, we're only limited by our imagination, but at the end of the day, I mean, you know, I am concerned that this has, first of all, a relevancy issue. You know, I mean, because of the different charges, and I understand. The court's you've already said.
I tend to think there's relevancy here as to what was going on, but the problem I've got because of what they did is the difference in the charges.
Right, and that's where.
Then I get into is it more prejudicial than probative part of the analysis, and I'm not sure that can be cured by a simple instruction.
I would agree. And the, and you know, and also, you know, 403, you know, we hear it argued a lot. We do. And you hear it thrown around a lot as a reason to either let something in or not. But this is an instance where I can see why 403 was drafted. I mean, I can see the purpose of 403 in this setting, you know, which is, gosh, you know, you got kind of this separate and different event over here. You're trying to equate it over here. The one thing that I'd say is, in addition, factually, is no, we've got two other theories that we've put forward to the jury in very clear sense. Is no, they trained him for a materialistic act, provided material support for a terroristic act, and there's three of those. There's one, killing police officers; two, killing politicians; and three, kidnapping a governor. I mean, that's the sum and substance of the theory. I mean, at the end of the day, I mean, I do agree with Mr. Kirkpatrick. And this kind of goes, I think, in the direction of 403 being a bar. And I said it when I stood up for my 2-hour opening. When I said it's a simple story. It's, did these guys help train a terrorist or not? I mean, that's in essence the thrust of this case is, did they provide material support to Adam Fox for a terroristic act? And in what way now I bring it back around to the ask, and the ask is, let us bring in the acquittals. And if you're going to bring in the acquittals, we're going to bring in the convictions. Then, okay, if that's the simple issue, then how does what happened over in Grand Rapids really have, any ability to help this jury decide the issues in this case?
Your Honor, I think he answered the court's question, but I think he answered it on our side. If you're going to say that, well, in my opening, my 2-hour opening, I talked about this is the act that they did, then how do you extrapolate that out to now we're also going to include, threats against law enforcement, which I didn't hear here in the last several days. You're going to bring in that they were, out to kill politicians. No, it has centered around, all of this has centered around Governor Whitmer and the plot to kidnap her. They can allege the rest of this and argue it, but I don't think there's one person out of these 15. But if we're going to say,
we did hear testimony when they all rode down to Detroit about if they're getting stopped or if there's problems with the police, they're going to shoot them.
But they were talking about policing the police at the Black Lives Matter. They weren't talking about we're going to go down there and just kill cops.
No,
and that's what was alleged back at the exam, the preliminary exam, and that's how it's kind of unfolded. But that aspect of it was not materialized. Second of all, if we're going to say, you know what, this is the crux of it, which I think we believe that it was the governor's case. Well, in effect, you had 4 people, 2 acquitted and 2 convicted. That's the balancing act. So the court can easily say, hey, look, out of these 4 that we're talking about, and I get, agent, that there was 6, but these are the 4 we're referring to.
And you
right?
also had the plea agreement with them.
Right. And if they want to put those in there, then fine. And put in the ones that have been sentenced. Bring it all in. Again, it's the truth and it's the whole truth. I'm not comfortable with us continuing to tap dance around some parts, putting some stuff in and some not. Let these 15 people or the 12 that are left have all this information and go, here's the deal. We trust you to be on here. We trust you to make decisions for these 3 men's lives, but know everything. Don't know the pick and choose that we've continued to argue about since the start of this. Let's give them all of the information and say, here it is. Because if we're going to say, if we're concerned that it's relevant and prejudicial to say these 2 were not guilty, fine. Say that these 2 were convicted and say that these 2 took plea deals and put it all out there. But let these people know everything and make that decision that we've entrusted them, and in this country that we've entrusted these people to make since the inception of the jury system, and say, here's the information, do with it what's right. Because I don't know that there's one outweighs the other. If we're going to say all 6, right, 2 took pleas, 2 were not guilty, 2 were guilty, it almost evens it out, but it gives the relevance to this is what really happened. And this is how it has unfolded over the course of this case. And they're all lumped together because we keep saying the watchman, the watchman, the watchman. Well, Ty Garbin's a watchman, and Brandon Concerta was a watchman, and Daniel Harris is a watchman. So if we're going to lump all these watchmen in, and I agree with Brother Counsel, right? We kept saying, well, these watchmen and these watchmen, and we're going to put their words up there, but without, and as Mr. John said, we can't make them come in and testify, right? I can't put Dan Harris on there. So what I end up getting is their almost hearsay, if you will, words of what Daniel Harris said, but I can't query it. I can't drag that out. I can't get what did Daniel Harris say as part of it. Why do you
say the hearsay if they're from a recording?
Because because they're putting this in, right? It's his words, he's reading it, but I can't sit here and say, Mr. Harris, tell me what this means. Tell me, what are you talking about? They're just getting their side of the story because I can't draw that out of him. I can't put him on the stand. I can't make him come and sit here and say, Mr. Harris, tell me about X, Y, and Z, because I can't give him immunity to what he's going to say. So when he says, I take the fifth, but I'm stuck with that. So again, we're stuck with some of the truth, but not the whole truth.
Your Honor, just, I promise, 2 seconds,
No, go ahead.
because he just made me think of something. We also had hearings about these co-conspirator statements. The court made a ruling to let all these co-conspirator statements in,
Right.
which is why we couldn't object to these co-conspirator statements. Well, guess what? 2 of these co-conspirators that were a part of my client's alleged ghost group that went off with, through Dan to Adam Fox, were found not guilty of conspiring to kidnap the governor. So here's what we got. We got all these co-conspirator statements come in. We can't cross-examine them because the prosecutor's not giving them immunity, so they're not going to come in and testify. The jury hears all these statements from all these who Agent Impola has classified as they or the Wolverine Watchmen, and continuing that connection through the co-conspirator statements. And yet the jury is not going to be able to hear that these very co-conspirators, which is why they got the statements to begin with, were found not guilty of conspiring to kidnap anyone. And so that yet again is why it's relevant, because that's the only reason you let all these messages in, Your Honor. We had an in-depth hearing on that, and the court allowed for these co-conspirator statements to come in. That's why we had all this hearsay in this case, all of it. And two of their main, I would submit, 2 of their main ones, absent Adam Fox and Barry Croft, were in fact Dan Harris, Brandon Concerta. And me personally, I'm perfectly fine with the jury hearing that Adam Fox and Barry Croft were convicted, but I'm asking that the court allow for the court allow for that. I mean, again, these statements coming in under the co-conspiracy theory, I think that makes it very relevant, and I think it's more confusing. It's more prejudicial to my client, number one, and it's more confusing to my client or to the jury when you allow all these hearsay statements to come in, testified to by the agent, and yet 2 of these co-conspirators were found not guilty of the very act of kidnapping the governor. That's the problem I have, Judge.
Let me just help out here for just a second. You know, they're claiming like they're victims over here about all this hearsay came in. There's not an ounce of hearsay come in. I mean, the co-conspirator statement rule, I mean, that it's not hearsay. There was no hearsay that came in. Those co-conspirator statements they're not, by definition, ergo, they are not hearsay. I mean, just because they got in with a bunch of knuckleheads that wanted to do evil and violence, and they all talked about it, doesn't mean they're being victimized here. No, we're following the rule of law of our state under the hearsay rule that, you know, those statements come in and the court ruled they come in because they are co-conspirator statements. They are not hearsay. So in this idea that, and what they're arguing here is, Judge, we're unfairly being, you know, prejudiced here because we can't get our statements and our testimony in that we want because they're getting so much hearsay in over there. No, we didn't get anything in that we didn't deserve under the rule of law, Judge. And they're trying to claim victimization of hearsay. There wasn't a single syllable of hearsay that came in because they were co-conspirator statements.
Which is what makes the acquittals even more relevant, Your Honor.
As I stated earlier, I see the relevancy. You're asking the jury to understand the difference between the federal charges and the state charges. And also see some probative effect for defense counsel. The problem I've got is the prejudicial effect of having the juries being able to sort out all of these differences. And making the differentiation in this particular matter between the federal charges and the state charges, I can't get over the fact that the prejudicial effect that it could have in making a determination of whether or not they provided material support. And no matter what happens, this would, no matter how I rule, this is going to be an appealable issue for either side. I'm not going to allow it in.
Thank you, Your Honor.
Thanks, Judge.
Your Honor, can we still take a break for about 10 minutes?
I have one quick issue, Your Honor, just if I can bring up, I would ask the court to reconsider in regards to my earlier objection in regards to Mr. Schoenberg and what he submitted to Jada in regards to the jail call we heard. The privilege has to belong to Mr. Morrison. And if he's telling her
That's why they
to
tell you that
represent,
all recorded at the time of the, and you're asking a third person. So I call my buddy and say, hey, what's going on? What are you hearing? And that buddy says, well, your attorney wanted me to ask you this. Why does that privilege, that would, any incriminating statement would then be subject to privilege.
not when it's only when it's prefaced by his wife telling him, hey, your attorney called me and I'm supposed to find this out.
But why not? The attorney knows that those calls are recorded.
We don't know what that attorney knows at this point, Your
yeah,
Honor.
okay.
And I'm not trying to
That's
impugn, but I mean, let's be serious, right? What attorney would say, hey, when you're talking to him, find this out for me?
But that's the problem with that attorney. And
But the
he
problem
was,
is that
he,
then if-
that attorney was their, from what I'm getting, is their go-to person. If they get in trouble, this is who they're gonna go to. And I just can't imagine an attorney using a third party who is not an attorney where you could get privilege to attach. Because as soon as there's a privileged communication, they don't record it.
I understand, but he queried this. And again, how's Mr. Morrison supposed to know? The privilege
I'm not
belongs to him.
suggesting that Mr. Morrison should be able to differentiate, but the attorney that he's getting the question from should have known that those calls are going to be recorded. They're not going to be privileged. They're going to be recorded. Any third person that calls up, if I call up and say, I'm, Tom Wilson, and I am the attorney for A, B, or C, I need to have a privileged conference with my client. And the recordings don't take place at that point. I don't see how you get around that. Just because the attorney says, I want you to get this information. I'm sorry, that attorney should have made a simple phone call on his own.
I agree with that, or come up here, or Zoom, or any number of things.
yeah.
But now my client is being prejudiced by the ineffectiveness, if you will, of that counsel.
I don't have a problem with that, what you just stated. That was who they chose to rely on. I'm sorry that he didn't understand that all communications between an actual attorney and their client are not going to be recorded. Nobody's going to be listening into them, and they tell you right at the beginning when you call in, these are recorded conversations.
I appreciate the court
I
reconsidering.
but I totally,
can't think of one that play right now.
all I can say is I think
I don't expect you to do all.
Okay.
I had concerns, and that's why you're here.
Thank you, Your Honor. I appreciate the court giving me the moment just
Go ahead.
to raise the issue.
Before we took to the record after lunch, we indicated that we had some exhibits we needed to look at before the cross-examination by Mr. Johnson began. And I'm not sure who's going to go first over here, but okay, it sounds like we need time to look at some of those. And
How much
maybe,
time?
probably 15, 20 minutes.
Okay.
Thank
You
you.
just let me know when you're done.
Good enough.
Thank you, Judge.
Thanks, Judge.
Hey, off, Dave.
Going off.
So I think the only other hugely long substantive one might just be Dan, Judge. And then we've got about like,
How long do you think Dan's gonna be?
A lot, significantly shorter than Special Agent Impola. But obviously, I would expect direct to last 2 to 3 hours probably.
Oh. Okay.
yeah, we put nearly 300 pieces of evidence in with him. That's why it took so long.
But how long do you think overall? I'm not gonna like hold you to it, but I'm trying to gauge my schedule.
A week.
And I can see the next raft of witnesses are gonna run fairly quickly. And I would think we're gonna probably, I can see cresting over into next week.
You guys?
Depends how, I mean, I'm at a loss because, and it's fair that we don't know how long cross may be. I mean, but I can see the balance of this week for sure.
Is Dan
Oh,
next?
Dave Ramirez will be next.
Oh, okay.
Yeah.
Okay. So, yes, you probably ought to mention to Nadine. They're in week 3.
So is it safe to call off witnesses for the October 17th, Deshaun Ellis trial?
That's October 24th. But I think so. You don't want to start an arson jury trial in between this and going
Well,
on
I'm
vacation.
gone the 31st.
Whatever the court tells.
Yeah, no, I'm just letting you know, the
All right.
31st, and I got hotel rooms booked all up and down the coast. And
So you want next week?
So the case is for the 17th, we can let them know.
All right.
Okay.
I
We
noticed.
will not be here that week, Judge. We will not. We will not.
The 17th?
No, I'm saying that following week. I don't
Yeah.
think we're gonna be here.
Okay.
Judge.
The messenger.
Yeah.
I'll take care of a lot of stuff that week, but anyway,
Can I address a couple of things, Judge?
absolutely.
Thank you. So we received some exhibits from Mr. Musical's attorney. There was a number of things that we are not objecting to, but there was a few things that we are objecting to, Judge. We received two clips and a 5-hour interrogation that Agent Impola did of Steve Robeson when he was a target of a separate investigation for felon in possession of a firearm charges after the arrests in this case had already happened. The background on Mr.
There has to be a
Robeson.
lot more to felon in possession. There was obviously more going on.
There is more going on, Judge, and just for background, so Mr. Robeson has been kind of mentioned peripherally in this case, having been in Wisconsin, Judge. And, he was a source for the FBI and then kind of turned double agent. And after the arrests in this case, he was actively seeking out Dan's location in order to do harm to him. And then after that, Judge, he was charged with felon in possession by U.S. Attorney's Office in Wisconsin. So a separate sort of thing going on there. Agent Impola, Agent Chambers, they went to Wisconsin as part of that, and they had an interrogation of Mr. Robeson that lasted 5 hours. What we were presented with here, as far as what the defense, I believe, is trying to get in, is that interrogation. While a search warrant is being executed at Mr. Robeson's home, there's this interrogation that's going on with Agent Impola. One of the clips is a mic check of the mic, which is 30 seconds, where they were testing audio. Robeson's not even present, so I have no idea what that's about. I would object to that. There's no relevance there. The second is a clip where it is 3 minutes of part of the interrogation that Agent Impola is doing again on Robeson. They don't believe is relevant. And the third thing was the 5-hour full interrogation. So I'm asking, these things are unrelated to this case, have no relevance, and are part of an interrogation on a wholly separate matter. So that's one set of things, and then I've got more, but maybe we could take it piecemeal.
As to the Robeson interview, here's why we believe it's relevant. Number one, it confirms that during this investigation, Steve Robeson was an agent of the FBI, which makes things that he said a part of Agent Impola, who we understand was not the handling agent for Agent Roberson was talking to Agent Steve Roberson about several things. Okay, it is our position that Steve Roberson was sent to be a confidential source in regards to Barry Croft. That Steve Roberson then pulled Barry Croft down to the meeting in Columbus. He rented the rooms, he provided marijuana, he provided food while he was there. Barry Croft goes back, Steve Roberson goes back to Wisconsin. Steve Roberson then meets with Adam Fox. There's a whole list of things that Steve Roberson does while he is a confidential human source for the FBI, including never meeting Mr. Musical, never having a conversation with Mr. Musical. We believe that although they indicate that Adam Fox and Barry Croft were the of their chart, we believe and intend to argue, no, Steve Roberson should be there. And it becomes relevant because throughout that investigation, that interview, Agent Impala talks about everything that they did to keep Steve Roberson's name out of the Michigan complaint. He talks about why, how, what type of witness he would be to the defense and how detrimental he would be to the prosecutor's office. And it is our position that Steve Roberson was indicted not because he possessed a firearm at militia training that he was going to on behalf of the FBI. He was indicted because they wanted to cut ties with him because they knew what type of witness that he would be. And so by cutting ties with him and charging him, he could then plead the fifth and not be compelled to testify. Goes on to talk about how the surveillance was pre-planned. And we talk about Cambria, Wisconsin, and things that Steve Roberson says in both the Columbus meeting and the People's meeting that are echoed by Adam Fox and Barry Croft. And we believe that when you listen to what he confirms about saying on the audio and the audio of those meetings, that Adam Fox and Barry Croft are just repeating things that Steve Roberson says. And at one point in the interview, Agent Impala says to him, if you were my CI, I would have whacked you on top of the head and said, you can't do that stuff, right? In terms of things that he was doing while he's pushing this Wisconsin part of this investigation. And as they indicated, all these things merge. So the relevancy of it merges in terms of what the actual intent was. We believe that the People's meeting, one, Adam Fox showed up like 5 minutes before it was over. And it was so dysfunctional and so disorganized that nothing got done. And Steve Roberson is just ranting and trying to, in our opinion, incite people to do things that would be illegal. And that goes to the context of their exhibit when they show that Joe in the leadership chat asked, how was Ohio, the second Ohio meeting? And the response was a hot mess. Tell you about it. And we're going to say why, that it was because of Roberson, and that no plan, well, that's not in the interview, but it's going to go to our argument that there was no plan still out of that People's meeting because it was a complete, utter mess. And so although some of the things that are in the video would be for impeachment, right? And not offered, as substantive evidence, I agree. We provide it so we don't have to do this back and forth. The agent's got to refresh his recollection for, the recording every time I ask him, well, didn't Steve Roberson say this? And didn't you ask him this? And didn't you say that? We can keep it all out the way. But things that he confirms that he did or that happened while he was a confidential human source, we believe those are our party admissions, Your Honor, and should be allowed.
Judge.
And because they intentionally kept him out of the paperwork, because in Agent Impala's own words, this is his strategy, that he takes a confidential human source, adds a bunch of witnesses to confuse everybody, hopes a defendant flips, and then that confidential human source doesn't become necessary. And look at exactly what happened in this case. We have a boatload of exhibits, a boatload of witnesses, a presentation that for 2 days was out of order, and that confirms what he says his strategy is. That's a party admission. And those are his own words in terms of what his plan is in these type of investigations.
Judge, I disagree with much of the way counsel characterized that, but regardless of my disagreement with the content of what he said, even if everything he said in his content was true, sounds like he's trying to run an entrapment defense for Barry Croft and Adam Fox during this trial. He talks about the People's meeting. These guys weren't at the People's meeting, right? So sounds like an entrapment defense for Barry Croft and Adam Fox, who are not on trial here. Steve Robeson had minimal, if any, contact with any of these individuals. The only time he could have actually had contact with anyone is Mr. Bellar when he was in Cambria, Wisconsin, which again wasn't central to our presentation in the direct in our case. But this is an entrapment defense for two people that are not on trial here.
They can't now talk about how our clients weren't at Peebles or Columbus when they spent all that time over the past few days talking about Peebles and Columbus. And it's not an entrapment argument. What it is, and the court would preclude me from arguing that Mr. Musical was entrapped, which I'm not. My argument is that Mr. Musical didn't do anything, or that was the material support of terrorism. The issue becomes when they play statements of Adam Fox and Barry Croft from these meetings, if chronologically those statements were made after Steve Robeson said something, then it's relevant for impeachment purposes as to whether or not these were actually the ideas of Adam Fox and Barry Croft. Furthermore, if
we didn't play this,
if you did play statements
of Steve Robeson,
of Adam Fox and Barry Croft, you played statements of Adam Fox and Barry Croft from these Columbus meetings.
Oh yeah, those.
Yeah,
but not for Peebles.
No, but we're going to get into Peebles. You didn't play anything from Peebles. You addressed Peebles, but didn't play anything from Peebles.
Yeah.
We're going to get into the actual context of Peebles. And part of our argument is they didn't play Peebles because Peebles was a hot mess. So although they referenced it, they didn't play it or talk about it because it was a complete, utter disorganized mess. And the audio confirmed that, and the interview with Robeson confirms that. Now we talk about, and the reason why that entire time frame is relevant for reference purposes is Mr. Musical is not mentioned. A person that they say was at the high end of their chart is not mentioned, even though they say there was this merger between the Watchmen and these other groups. I think they called it these three threat levels merging. He doesn't talk about them at all. And it's also, again, though, all the admissions that Mr. Robeson makes are relevant and they're admissible. They are statements of a party opponent. When he was a confidential human source, he was a party opponent. They have argued that somehow Mr. Musical is criminally culpable for all these statements made by people he had never met, which would include Barry Fox. He never met Barry Fox. Barry Croft in person either. Okay, it was just through Facebook and talking. So when we talk about these things and what he said, and again, Agent Impler's own statement. Now she can make her argument to the jury as to what Agent Impler meant when he said, "Oh, we intentionally left you out of the Michigan complaint." And one of the things that I do in these, and I'm paraphrasing, investigations are, add a lot of witnesses to confuse everybody. And what typically happens is somebody flips and you don't have to come to court. They can play, that statement, like we're going to play the statements that they've played, and she can make an argument.
They had a lot of witnesses, a lot of potential charges.
Pardon me?
That they potentially could be charged.
No. What Agent Impler, and I'll close down my transcript of what exactly he said. So I'm paraphrasing. What he said, what he's explaining to Robeson, because Robeson's upset that he may have to testify.
How about we just play the two clips you want to play and let the judge hear it?
That's
because
fine. I'll close down my computer, but
we're ready right here.
Yeah, there's a 5-hour interview, and then we've gotten the whole 5-hour interview, and then there's two clips, and we have them here, Judge. We could just play them for you, and then he can tell you what the relevance of this is.
Judge, rule of completeness.
Yeah, but just the other 5 hours provide relevant.
Right, Your Honor, I shouldn't have even said anything. I apologize. It's not my exhibit, but
yes, because the reason why the other 5 hours are relevant because he hasn't mentioned that it's relevant.
Well, I'm not going to listen to 5 hours of tape, just find out he isn't mentioned. Is there parts that you want to bring out?
Yeah, there are parts that we're going to bring out, but it's available. If the jury doesn't want to listen to it, they don't want to listen to it. But that is something I wasn't gonna sit here in my cross-examination and play all 5 hours.
Okay, that's what I was
Yeah,
getting
yeah.
at. I don't want to listen to,
Yeah.
you'll put them to sleep.
And Judge, one more thing, the 5 hours, also, again, this is an interrogation of this individual on a wholly separate topic. So if there's certain relevant parts, maybe that could go in, but again, this is like 5 hours of tape of Steve Robeson getting interrogated on his own felonies, you know? Okay, I'm sorry, I'm ready with the 2 clips that they provided us.
So this is clip 1. It's titled 12-10-20 Impala, you can't handle the truth.
I want the truth.
I can't hear
Yeah,
That's so volume's at 100%. That's testing of the mic.
Mr. Robeson's not even in the room, Judge.
This
There's
is
the second one.
it's a 3-minute clip. It's titled 12-10-20 Paid Liars.
I think just so we're on the same page, we need to understand, because we saw Facebook messages where you and Croft were talking, and then you're kind of putting governors out there and politicians like, hey, these guys are corrupt.
Yeah, I really wanted to see where he was going, you know, I did, I wanted to see what level it could go to, you know, and especially since he had a year of a lot of people.
Sure.
And I did, you know, those were just in basic conversations. And then even after I became, you know, a force, I even still stayed in those conversations.
Right.
I just did, because I wanted to see where they would, I wasn't sure even when I became, back then, I just thought this guy's off his rocker on the.
Yeah.
And then, even after I became, I still was.
Right.
But then more and more and more, I'm like, yeah.
Serious, right? And so in retrospect, right? So when somebody reads those stuff, and this is something that we're all gonna have to overcome, is somebody reads the conversation between you and Croft from 2019. There's a portion of you where you're saying like, hey, these politicians are corrupt, you know, there's tyranny, they're not constitutionalists.
Right.
And then Croft like takes up the banner, yeah, let's go after the politicians, right? So the question, you know, from an independent, like we know what's going on, but it quickly becomes from a defense strategy. Well, this was Roby's idea from day one, right? Like that is an option on the table. This is Roby's idea from day one, right? He's the one.
There was a lot of phone conversations too, you know, he
Okay.
drives, so he talks, if you look at his phone, from the time he gets in his truck till he gets out of his truck, hours and hours later, he's on the phone with somebody.
Right.
And he's saying what he's thinking, you know, and that's where it wasn't on Facebook, I don't think, when the first concern came up, I think it was that phone call. But again, I think you guys know all that, you need to have lots of conversations on that.
Well, and, you know, he's trying to explain, you're correct. We know, we actually know the vast majority of what happened and what was going on. But we need to talk about what a defendant or a defense strategy, how they're going to try to portray what happened and how they're going to try to twist it to defend their client and to try to blame somebody else. And that's kind of, yeah, that's their job.
Right. And I mean, and you know, they're paid liars, right? They're paid to take the truth and portray it in a different sense.
To create reason. Yeah, that's what they're trying to do. They just need the one word, right?
So, and they're gonna look for those weaknesses, right? And if they perceive Robeson as a way to do it, they'll go for it, right? So, all right, so kind of on the.
That's it.
That's the second one. The third one then is the 5 hour.
So again, Judge, I don't think it's saying any of those things. I think what I'm hearing at least is that he's talking about what might happen with Robeson's words being twisted by the defense. So again, it's not proving anything I just heard out of Mr. Johnson.
You know, what the second clip proves is they spent the last few days saying that it was the Wolverine Watchmen that put out this idea of kidnapping politicians and governors. And you just heard from their own mouths that Steve Robeson was talking to Barry Croft about that all the way back to 2019, which would have to be at least based on their own exhibits 4 months prior to any communication between the Wolverine Watchmen and Barry Croft. That's why that part is relevant.
The
And
only
what they're
thing
doing,
referenced
I'm
is.
sorry, I'm not finished. And what's also what they're doing is, because I'm thinking, how many recordings of the briefings do we have between Agent Impala and Dan?
What?
How many recordings of the debriefings between the FBI agents and Dan do we have in this case, right? I don't think we have any. So it's important what they're talking about. And if you listen to it, and what the evidence allows me to argue is that they're leading him.
Yeah.
They're leading him on how to answer and what defense strategies may be and how they need to protect and secure those witnesses, or excuse me, that testimony to protect against that.
This is an interrogation, Judge, not a debriefing of a witness or a source. They're not the handlers for Stephen Robeson. This is an interrogation of Stephen Robeson.
And in that interrogation, it comes out that Steve Robeson was talking to Barry Croft back in 2019 about kidnapping politicians. And so any argument or any presentation of the evidence that suggests it was these guys that brought that up is impeached, Your Honor.
Judge, that was before they ever met Barry Croft that they started bringing it up. But again, Judge, we're talking about an entrapment defense that he wants to run for Barry Croft, essentially. How is that relevant to this case?
Yeah, I don't know how many times I can explain it. It's relevant because they're presenting evidence that suggests these individuals met Barry Croft. There was Facebook messages, there was Facebook phone calls, there was DMs, and they came up with this idea of kidnapping politicians. The recording impeaches that theory. It shows that Steve Robeson was talking to Barry Croft about kidnapping politicians back in 2019 before any of these individuals had met Barry Croft.
So then what? That then Steve Robeson entrapped these guys? Is that where this is going? Because again, it's another entrapment argument, Judge.
It's not an entrapment argument, it's an
I don't see it
impeachment
as an
argument.
entrapment.
Pardon me, Your Honor?
I don't see it as an entrapment.
Thank you.
It'll come in.
Thank you. Thank you.
All 5 hours, Judge?
Well, the all 5 hours, if the court is not gonna put it in, it's not gonna put it in. But without,
I don't want to listen to 5 hours of.
I know, Your Honor, what
Nobody does. I mean, you're gonna put them to sleep.
No, but I don't, when there's maybe other things for impeachment purposes, I may ask about that 5 hour tape, but that doesn't come in as intrinsic evidence. I understand that, but I just offered it so they know, hey, he's gonna be questioned about some things that were said.
Judge,
And we can play
you know,
the relevant-
there's been if I can just jump in for a minute here and get some clarification. I hear Mr. Johnson saying two things. At one moment, he's saying, I want it to come in, and the next minute he's saying he wants it as impeachment. If it's impeachment, it doesn't come in as an exhibit.
We're talking about three different things. Audio 2 is an exhibit. Things that are said in the 5 hour are for impeachment,
Okay, so,
okay.
because I've heard him saying that the 3-minute tape is for impeachment also. I mean, at any rate.
And then the first one, the mic check, was that just random, or are you going to use that?
No, there are times in that recording where it appears that the microphone cuts off. And so that mic check is to confirm with the agent, you tested this microphone. This microphone appeared to be working. There should be no reason why there appears to be gaps, if he agrees that there are gaps in that 5 hour recording.
So the point of playing all 5 hours is to hear gaps.
No, Your Honor, there are going to be things that I'm going to question him about that are in that 5 hour portion of the recording. The court has said you're not going to admit all 5 hours. I understand it. So what I'll do is I'll specifically, because I can ask leading questions, I'll specifically reference where in the recording I'm asking, and he can either acknowledge that it was said or not, and then we can impeach it. That's,
Okay, should I move on to the other objections?
Okay, yeah, that sounds reasonable, but I'm
not,
playing 5 hours
absolutely.
is gonna put the jurors to sleep.
Yes, sir.
Judge. There is one picture of a group picture from Wisconsin labeled 7/12/20, and it's Fox's post of a picture in Wisconsin. And I believe, again, it's an entrapment argument. I mean, there's one picture I have no problem with, which is just a group picture of people that were at Wisconsin. I don't have a problem with. The second picture you sent me where that picture is embedded in a Facebook page, that's the one I'm objecting to. Is there any reason you need that one?
Yeah, part of our, my argument, particularly this Peak Musical, is that during the 7 months, there were several different gangs that were founded. Okay, it's our argument that the Wolverine Watchman was a training group, that the QRF was a separate gang or subset. However, the court wants to clarify, the jury wants to clarify it, that Bonfire was a separate gang, that the individuals that went to go train at Cambria and ultimately Luther created a separate gang that coincide with separate chats, and at one point even switched to from wired. Okay, so that is the portion of that video, that photograph, and it also goes to show that because they talk offset. So they wasn't worried about no offset. They took a photograph of everybody there and posted it.
Judge, my understanding was that counsel had said it during his opening statement that, you're going to find out that there's all these groups around the country and the government is the one that, set up all these groups and things like that. And so my understanding was that that picture would be used for an entrapment argument again about the government setting up Facebook pages for which to share this content. That's why I was objecting to that, because I believe that's entrapment again. And again, not related to these three.
The Michigan 3% was set up by a FBI confidential human source. The purpose of that is, and it is.
You mean their Facebook?
Yeah, it is referenced in the chats, which I was going to get into in my presentation, that Adam Fox was so lazy and unmotivated that he wasn't going to do anything. And so that, yes, he is not committed, to this thing. And it starts from the very inception when the confidential human source has to set up the Michigan 3% Facebook page. That Adam Fox is just smoking and talking. That's all he's doing. He's getting high and talking junk from that, and it goes on to Back Shack. It goes on to when he finally shows up in Peebles. We think that we can establish that there was smoking going on at Dublin, that this is a consistent thing, that there are text messages from the agents telling me, hey, you got to get Adam focused, right? It goes to materiality, whether or not these guys could have materially supported somebody who was so lazy, he wouldn't even set up a Facebook page. So no, it's not entrapment, Your Honor. It goes to.
Does he know how to set up? Anybody know if he knows how to set up a Facebook?
I don't know, but they can answer that question.
Again, Judge, this is all a great defense if for Adam Fox and his lawyer to have worried about during their trials, which clearly didn't work. But I guess what I'm saying here, Judge, is that, again, this is an entrapment argument with Adam Fox that has nothing to do with this.
Why?
I'm sorry, Your Honor. And also, I'm sorry, at this point, it also goes to show that Adam Fox had a separate gang, or at least thought he did, right now. So it goes to how material were the Wolverine Watchmen if Adam Fox had the Michigan 3%ers. He was never a Wolverine Watchman. No member of the Wolverine Watchmen ever became a Michigan 3%er, particularly the ones that are sitting at this table. And the individuals that do go to Luther to train or to Cambria to train, in which Adam Fox is there, never pledge allegiance to his group. So it goes to the argument, these are separate gangs, so to speak, to use their terminology, and that they weren't merged.
And separate gangs, irrelevant, Judge, again, because we're not charging that gang or his gang or Adam Fox here, right? But them merging, there's been no testimony about merging gangs. There's
Well, not
been
merging.
testimony about
We heard
merging
three
threat streams.
Separate threats.
Yeah.
Merging.
The investigation, 3 separate investigations were merging, not gangs merging.
Well, you had 3 separate ones coming together at some of these.
At one event, Wisconsin, right? Yeah, 3 different groups, right? Or not 3 different groups, Judge. It's not about gangs coming together. It's about 3 separate threats. So 3 separate investigations by the FBI coming together at one point, right? But again, the fact that Adam Fox has his own gang is no moment to this case here.
They're using the word threat because they don't want to use the word gang. But the threat was Barry Croft and the Second Continental Army they thought was showing up. The threat was they thought the Wolverine Watchman was showing up. And the threat was that Adam Fox and his 3 percenters, which was just him, Sean Fix, and Undercover, were showing up. So the 3 threats, we talk about tangible things here. The 3 threats were these groups, okay? And it is our argument that these groups never agreed to work collectively. They always remained separate. And in terms of Pete Musico, it is our argument that he wasn't even in the gang, the QRF, that went to Cambria, Wisconsin. Now, they're arguing that, he sent these text messages and asked people stuff, but we're going to get into, why these were separate groups. And I don't want to go too far into my cross and tip my hand, but I think that it's fair to show, in which they've already conceded Adam Fox was never a Wolverine Watchman, but then it goes to materiality, right? They're saying that my guy was in material support of terrorism because he provided facilities, he provided training, he provided personnel, right? So it all goes to, if Adam Fox has the Michigan 3 percenters, he doesn't need Mr. Musico's personnel. If Adam Fox had access to other places to train, he didn't need.
I thought I heard testimony that these guys, that there was testimony about them knowing what they were doing, that they were going to be able to train him up.
And we're going to get into that and impeach that because it's going to be our argument that Mr. Musico did not know what was going on in Wisconsin. And I guess, they put me in a position where I have to tip my hand on my cross-examination. Good job by them. But going back to the 5-hour interview, Agent Impola asked Steve Roberson, he says, hey, one of the things we got to clarify is this Cambria, Wisconsin thing. Was this just regular training that got shanghaied by a group of terrorists? Or did everybody know what was going to happen at Cambria, Wisconsin? That goes directly to, Paul's situation where he says, hey, we're defensive. This is a defensive group. And Dan says, well, you got to keep an open mind. Those things, corroborate each other in the terms of they're talking about whether or not in that interview, Steve Roberson knew that terrorists supposedly were coming to train at his location, or was this a family fun event that everybody showed up, that there was some secret stuff going on at that training. And when you see the actual pictures.
A family fun event.
Yeah, see, what they didn't do in their direct Impola is they didn't show any video or pictures from the training. There was kids.
Oh, I know
there was
there were
barbecue.
kids. You could hear the kids in the background on one of the tapes.
They were swimming. They were eating hot dogs and barbecuing. They were, shooting and training. It wasn't, what they depicted it to be.
Shooting and training for what?
Regular militia training. These guys have been 2A for as long as, we have evidence going back into their lives. Okay. And so what the court just asked is exactly what Impola is talking about. Impola is, I'm sorry. I'm so sorry.
No worries. Impola,
what Agent Impola is talking about in this parts of this 5-hour interview. What was this thing that was going on in Cambria? What exactly was it? Because agree, he's not the handling agent. And Steve Roberson's answer to that is very important because one, we believe it exculpates our clients, right? That Cambria was not terrorist boot camp. It was 2A, come have fun, come shoot. And while they were there, one guy, Adam Fox, and another guy, Barry Croft, are running around talking to select people about something.
Okay, so how is this any different than what we've been saying? Why can't you just ask questions about Cambria? Why is it that, we got to talk about a source, setting up pages, and now, he said like 14 things during that answer, Judge, about how this is all related and why Robeson's interview should come in. So again, if it's just a 2A friendly family fun event, you can ask input questions about that. We don't have to we don't have to have a 5-hour interview in evidence.
The side of the room that just spent 4 days on one witness is mad because wants to know why I want to go into detail about one of the events that they brought into evidence that my client wasn't even at.
I got
They
no
could have talked
objection to
about-
that.
they-
None.
They could have talked about just the week of the 28th.
She just said she doesn't care.
Pardon me?
I don't care.
Not objecting.
Right, but so we want to show the video. We want to play, we want to play portions of the video. We want to talk about that and show what Steve Robeson's answers were to that and show the full context through the questioning of Agent Impola in that interview. They keep talking about this as an interrogation for a felon possession case. But as you can see from both sides' argument, they talked a whole lot about a whole lot of other things. Wasn't no 5-hour interview or interrogation and regarding whether or not he possessed a 50 cal when he was ineligible to do so.
I don't think we're arguing about the same thing anymore. Like you made the decision that if he wants to impeach using the 5-hour interview, he can do that. That's what I've written down here. Right now, I was on the picture of the group posted on a Patriot 3%er page that again is an entrapment, what I believe is an entrapment argument for Barry Croft.
Just like the Wolverine Watchmen have a page with pictures, Adam Fox's gang has a page with pictures. That's the purpose of that evidence.
That's fine as long as it's not going to go into a huge entrapment argument about Steve Robeson entrapping Barry Croft, right? Like that's my issue here, Judge. It's just that one picture. The other picture I'm fine with, but I just don't think we're arguing about the same thing right now.
Got it.
Then I have just a couple more here.
Wanted to say something.
No, of
Oh,
course,
okay.
it's kind of,
Well, they said you can play the 5 hours. So I'm not sure what the issue is if you're gonna play it.
no, we're talking about the photographs. I'm explaining why those photographs and all the context behind those photographs and the page are important. Because remember, they are arguing that Adam Fox is a terrorist. I never said that in my opening statement. We can go back and review my opening statement. My position is that Adam Fox was just lazy and wasn't material into what Barry Croft ultimately wanted to do.
And Judge, material has a very specific definition in the law, material support. There's this whole, the act actually has a definition section and material support is very clearly laid out. And material doesn't mean what council's been saying it means. It's not like you have to give really great training or really great facilities. It's just training, facilities, financial support, like, any of those things. So again, it's like the definition of material support is already in the law. We don't have to interpret that.
But they don't define material.
Oh, but that's it. Material support is a phrase that is defined in the statute itself. It's in the definition section, the very front of the
Facilities,
act.
training, funds, but it has to be material.
No, Judge, it's, you've got to look at the definition section. The whole definition is, in quotes, material support means, and then it goes on to define what material support means. They're not separate terms.
Any one of those is allowed.
Correct. That equals material support. Yeah. The condition of that support, like the condition of the finances, the amount of money, the condition of the lodging, the amount of lodging, none of that is at play. Material support is defined.
Can you hold a case that suggests that?
Yeah, absolutely.
Where is it?
Yeah, I'll be happy to pull up the statute, Judge, and give you cases if you'd like. They come from the federal system.
No.
But-
We in state court.
No,
The
Judge, it's the
state
definition section of a statute. Just read it.
The state statute, where does it say where you just argued in the case law?
It,
Mr.
Mr. Johnson, it says it in the statute. Try reading it.
I've read the statute.
No, you haven't,
Statute
because you
says
wouldn't be standing there saying what you're saying if
of
you did.
terrorism, and it says the material support of terrorism are these things.
Yes.
Okay, so based on their argument, they're saying oh, if he gave a car, it wouldn't matter if the car broke down and didn't work.
Yes.
The fact that he gave a car.
If
Just
you
like
gave
if
a car knowing where they're going and what the purpose was.
Yeah. Just like if
Not
you
if
give the
car doesn't work.
Taliban,
If the car doesn't work, then how can give somebody a car be material support?
it's in the statute, Judge, but if you give the Taliban a box of guns and they already have 30 boxes of guns, you're still materially supporting by giving a box of guns. That's just how the statute is.
Your Honor, if we're going to talk about training being the material support, would you not agree that I have to know what I'm training this other person to do? If these guys are presenting defensive training as 2A, as we're defensive, as Mr. Beller said, hey, we're a defensive group and we're training to defend our homes and defend whatever. And you take it, not Your Honor, but the person takes it and utilizes that training for some other nefarious purpose. That's not on these guys, right?
Yeah, that's a different element. That's just a different element. Yeah, I agree with you.
But we're talking about the training, right? So if they're going to say, well, they provided this training to this terrorist, if I give the Taliban a box of guns, right, there's no question what the gun is for. But in this case, the training is at question. If that's what we're going to say, and which what was said in opening, right? These guys provided training to a terrorist. No, they didn't, because they didn't know that.
Okay.
And that's the relevant aspect of it.
That's the relevant aspect. That's exactly what we're here for, Judge. It's for them to decide whether, that's a different element than material support. Material support is the first element. What he's talking about is knowingly providing that material support is the second element.
The training is, if that is in the first element, providing the training, that is part of the definition of material support, right? But I have to know that I'm providing this training, because if they're coming
You're providing, like she said, you provide the training, then you get to the next part. Did you knowingly assist?
knowingly assist in the terrorist act,
right.
Not knowingly understood the training. That's two different aspects of it. I can do training without knowing the training is being utilized for this. Then I have to also know that it's being used.
And then you get to the next point.
The next point is, do I know they're going to?
The training, they have to accept the training as the support. And that's part of the picture and what's going on in Cambria. What happened at Munich was not the material training to any act of terrorism. That's what Luther was for. That's what Cambria was for. That's the point of this argument. They're trying to argue that any training whatsoever makes them guilty of material support of terrorism. Okay, and we can make that argument to the jury, and then we'll see. Okay, but that's why the photographs and things in the questions are important. Was what happened in Jackson County material? Was it material support of terrorism when he got his Facebook page somewhere else, right? When he trained somewhere else, when they did tactics somewhere else, when they did surveillance somewhere else without these people? How was this material training for a terrorist act? And it goes to what Mr. Kirkpatrick has been arguing from day one as to what the ultimate terrorist act was: kidnapping the governor. And did anything at—
Well, it was more than just kidnapping the governor.
Well, that's what they're going to argue. But it's our position that they know none of these guys, and this is what I said in my opening. These guys we counted had 10 encounters with law enforcement and never said anything even remotely disrespectful. They're only making that argument because they want to get 7 or 8 months of co-conspirator statements.
What about when they were at the Capitol?
Never said anything disrespectful to a law enforcement officer at the Capitol.
Judge, there's an argument here that's happening right now, I think, with the, they encountered law enforcement during the course of this investigation, and so therefore they didn't want to kill police officers. If you have a pedophile, just because they don't perp on every single child they encounter doesn't mean that they're not a pedophile. This is not a valid argument, but I'm not really sure why we're arguing this right now. Hang on a second. This is not a valid argument right now. This sounds like, arguments for a jury. I'm not sure if we're going down this list and we're talking, I'm not sure. Are we still arguing that picture from the training? Is that what we're arguing about?
That's where it started.
Okay, is there a decision by the court? You still want to keep hearing from us? Because I'm sure you don't want to hear from us anymore.
You have the picture.
Yeah, yep, it's right here, Judge. You want to take it up? Court? Thank you.
And you don't want this coming in? Why?
I wanted to come in.
Right, and I was saying, there's the picture before it, Judge, and I have no problem, it's just the picture. But what's I'm objecting to is how it's posted on this Facebook and then going detail into that whole Michigan Patriot 3%er page and who set that up. And do you know what I mean? It's like, the argument is the sources and the government set these pages up, and so it's entrapment. That same picture is the previous exhibit, Judge, and I have no objection to that.
Yeah. I don't see why the picture shouldn't come in. Can bring out who set the page up, but I don't see that as just because one person has skills, the other doesn't. Or because Adam Fox isn't computer savvy. That should be easy to deal with as far as, okay, you argue government's putting this guy up to it. And they're saying Fox doesn't know what he's doing, so this is the guy that can do it. He sets it up. Then when we get done with everything, you make your separate arguments to the jury.
Okay,
It's coming in.
sounds good. All right. The next thing, Judge, is just there are a bunch of text messages between the handler and Dan, Judge, which we kind of, talked about before when Mr. Kirkpatrick was seeking 11 particular texts, and I had no.
Yeah, I'm sorry, I didn't email you back. Whatever we sent that
The
day,
original was 11
correct.
pages, yeah.
Whatever that email is, are the only ones that I'm gonna.
And we resolved it in the back, I believe, by saying that he could ask Dan about them and impeach Dan with them if Dan was inconsistent in his testimony. And so I've received many other text messages, again, between the handler and Dan, and I'm just asking again that these not be exhibits that would be entered into evidence, but rather if Mr. Johnson wants to impeach Dan with them, then I can't stop him from doing that.
Yeah.
Yeah, so that's all, that these wouldn't come in as like independent exhibits.
Agreed.
Okay, issue resolved. Thank you for your time this afternoon, Judge.
That's it.
That's it, believe it or not.
Okay. Nothing else we got to cover?
For now.
It doesn't seem, in retrospect, pretty straightforward.
Yeah, there's a big disagreement about two things. Everything else, I think.
Thank you, Judge.
9 o'clock tomorrow.
Yes, sir.